that I'll just say we'll defer onto this one and make sure that they're noticed for the hearing.
What's up, True Team? It's your girl, Mickey Truth, SD's #1 urban blogger and the queen of paperwork. YNW Melly was in court today, and a lot of things was moving around. Some was granted, some was deferred, and even 1 to 2 was denied. So let's get into the recap.
We have Mickey Truth.
Who is this? You got Mickey Truth kicked out.
Shout out Mickey.
Let's get one thing clear. This your girl, Mickey Truth. So, as far as the motion in limine to prohibit the introduction of out-of-court statements and relevant evidence, this is as follows, okay? So, the first one was the YouTube videos of 1090 Jake, okay? 1090 Jake is apparently a YouTuber, who says the defense, who taunts his membership and knowledge of a gang called Bloods. 1090 Jake describes Bloods' criminal gang activities. YNW Melly was not in the video, nor did he make any statements during the video. The videos do not prove any material fact in this case. Any statements by 1090 would be hearsay, would violate Demon's right to confront witnesses, would be presidential, and would have no probative value in this case. The judge agrees, okay? So they granted that, so that would not be used in the witness tampering case, okay? Next, TikTok video of Neat Baby. Cortland Henry was charged co-defendant in this case. His case has been resolved. The TikTok video of Neat Baby was created by Cortland Henry's girlfriend, Geneva Malonia, or something like that, okay? Demons did not participate in the video and make no statements in the video. The judge agrees. It was granted. Next, statements made by James Howard. James Howard was in custody at the Broward County Jail during some of the time Melly was in custody. It appears he was subject of a separate investigation, and so his phone calls were being monitored by law enforcement. That was deferred, okay? Meaning the judge gonna think about it, and then he's gonna run it back, and then he's gonna make a ruling on that, okay? Next is phone calls between Cortland Henry and his girlfriend Melania, or however you pronounce it. The phone calls an issue occurred when Henry was arrested for the instant case, witness tampering. The state has listed a number of the calls in discovery. The judge agrees with the defense, and it was granted. Okay, so they won't use that. And side note, Chirac Humor is about to drop the body cam footage of when Cortland Henry was arrested. So we definitely gonna have a follow-up reaction to that. That'll be dropping later on. Okay. Next is hearsay statements containing writings and phone calls of Terrence Mathis. Terrence Mathis, which was the co-defendant on this case, who already played no contest, who will not, according to what was said in the hearing, testify at trial, okay? And that was deferred. The judge need more time to think about it, okay? Next. This is a big one because a lot of the viewers have been asking, is Cortland Henry taking a stand? Is Terrence Mathis taking a stand? Will their outcome of their cases, because they both have played out, be taken in consideration? Well, according to the judge, no. They have granted the defense motion to have the resolution of Cortland Henry case and the resolution of Terrence Mathis case kept out of the trial. All right, we almost there, y'all. It was a lot going on, okay? Shout out to everybody that put up on me on live. I'm literally live right now as I'm doing this recap. Shout out to everybody. Next, any mention of the court of the counts of the information that only charged Mathis and Henry, meaning if YNW Melly wasn't charged, they can't use it. And the judge agreed and granted that motion. The next, the facts that YNW Melly is charged with a capital felony, that's denied. Okay. Hey, the judge said at the end of the day, okay, he's charged with, even though he ain't got found guilty, that can be brought up at trial. Next, music lyrics published by Jamal Demons. The state has provided in discovery of a variety of lyrics from YNW Melly music career. The judge said, nah, we ain't got time for all that this go around, okay? So he granted that motion to have that not used, okay? Next, social media posts, Snapchat records, phone records, and Instagram messages from 2018 and 2019. This, during the hearing, is where the conversation came up if MH is going to testify. Of course, it wasn't confirmed at the hearing, but the judge even said I would assume she's going to testify, or MH going to testify. And I told you I believe she would have to testify. She's literally the witness in question. But he deferred that till trial and said he'll just go with it as it goes in. Okay. Next is evidence and allegation from the pending murder case. Now, this is where it gets tricky because a lot of the evidence was thrown out by Judge Murphy and upheld when it went to the appellate court. So the current judge made clear, like, hey, now that can't come in at all. Now, you talking about you got some new, you know what I'm saying, stuff, then we can look at it at that point. But don't bring none of that old stuff in here. Basically what he came up with. So that's the third, my bad, that's denied. However, if it comes up, if they try to slide in some of the stuff that's not supposed to be there, then they're saying, they can run it back. All right, we almost there, y'all. Let's see. The last one was any evidence of alleged drug smuggling at the jail. Y'all already know I talked about this in my last two videos. The judge agreed with that. That is out of here, okay? That's out of here. All right. So the next one was, hold on, what was that? Defendant's motion for statement of particulars as to count 2. That was granted. So, I did a video where the state did a reply saying, hey, at the end of the day, we ain't got to hold your hand to tell you how we about to play our case out. That's up to y'all. The judge said, no. You got to give a little more information. So they have 10 days to get that done. Really, that's close to trial. So that was granted. The next motion was to bifurcate. I got to break that down. Bifurcate gang enhancement containing count 1, 3, and 4. That was granted, so that's out of there. They kind of agreed on it. The one motion I'll have to wait till the paperwork come out is motion to inspect and photograph YNW Melly cell and conditions of confinement. I couldn't find out that part. I'll try to run it back. Okay. So with that being said, that is your recap from today's hearing. It will be no hearing tomorrow. However, the hearing will take place on January 12th at 8:45 a.m. You already know your girl gonna be here live in effect. Get in the comments. Is this the win for YNW Melly? Or should they not be too happy too quick? Get in the comments. Let me know what you think. Like, comment, share, subscribe. Tell a friend to tell a friend. I'll pull up on your girl, Make Truth. Catch y'all on the next one.
For the first 3 counts would go first, and then the count 2, the gang activities would be bifurcated. So, Zeus Buckaloo, you're moving to do that yourself.
Yes, sir.
Okay, so then based on that, without objection from the state, that one's going to be granted. The trial will go forward as to counts 1, 3, and 5 only for purposes of what the jury sees. I'm going to call those counts 1, 2, and 3, but on our information, it's count 1, tampering with a witness in a capital felony, count 3, solicitation to commit tampering, and count 5, conspiracy to commit tampering. Oh, okay. Let's see what you got.
I showed the kind of count.
Okay. Mr. Finley, no objection to this?
Okay.
Okay, so this one's going to be granted and entered. Give me 1 second. All right, yes, sir. What's next?
Regarding the motion to bifurcate gang enhancement as to counts 1, 3, and 4, the state has agreed to forego enhancement on those counts, and I think they should have an order, a UV order, and have no objection to the order as it's drafted.
That's correct, Your Honor. We're going on the gang enhancement on those other counts.
All right, so you're not gonna seek it at any point.
No, and the only caveat is if somehow the door is open, gang evidence up, but otherwise we're not going forward on the enhancement.
Okay, so hypothetically, if the defendant got convicted on one of those counts, you're not going to want to present any additional evidence, and you're not going to be asking for that enhancement to be included. Okay, so no objection to this order, Ms. Buckley? So then, otherwise, that one by the agreement of the parties is granted. Give me 1 second. Yes, sir.
Your Honor, the remaining motions, the statement of particulars and the motions for additional time to file motions for us, I'll let my field counsel and the Senate address those.
Okay.
And then I actually just thought of something on the motion to bifurcate type two. Because this is not proceeding is technically still running on count two then. So how would we go about that?
Well, I mean, my position would be once we start jury selection in the case, it's started. It's bifurcated only for purposes of how we're going to handle it. It's going to be the same jury. It's going to be the same trial.
Okay.
I think once jury selection starts, Speedy's been satisfied, but that's just my take. All right, so that handles those. So Ms. Howe, whenever you're ready, anything else you want to tell me? I got the motion for statement of particulars, the motion for additional time to file any motion to suppress you might like to, and your amended motion to eliminate, which involves several separate paragraphs.
Yes, thank you, Judge. And may I request that Mr. Demons have at least one hand on the docket for purposes?
Yeah, that's fine, Gary. That's fine.
Yeah.
Who is that lady?
Okay, let me just press pause real quick. All right, real quick 5-minute break, okay? We'll be in recess for 5 minutes. Okay, listen, he's got to have a hand. He's done nothing. He's behaved perfectly like a gentleman.
What in the world just happened? Can you move the chat off the screen? Why? What happened? Trying to eat my salad. Is it bothering y'all having a show on? Is having a chat on the screen bothering y'all? That lady is Drew's local counsel. Oh, okay, I'm like, well, I haven't seen her before. Y'all let me know. They on a 5-minute break. Cause I'm gonna say I normally keep it on there so I can keep up with what y'all saying. Cause if I look down and like I'm over here eating, I don't miss what y'all saying. We can't see the defendant's lawyers.
This is Jamel Demons, 23-10594 CF10A. I continue to have Ms. Buckley, Mr. Griffiths present in person, Ms. Collins present on the Zoom call, Ms. Howard, Mr. Finley present in person, with Mr. Demons who continues to be present. Yes, ma'am.
So, Judge, I would ask that the next motion we hear is the amended motion.
Sure.
We do have some agreements as to this.
Okay, you want to just go one paragraph at a time?
So paragraph 1, I believe is an agreement.
Yes, Judge, and same caveat, as long as the door is not open for whatever reason, we do not intend to enter that.
Okay, so as to, this is the defense amended motion, and the paragraph number 1, the YouTube videos by 1090 Jake, you don't want to use any of those unless the defense makes it relevant. So.
Correct.
Okay, so that one is granted then with that understanding. As to paragraph 2, yes, ma'am.
Judge, may I just ask that should the issue come up as to whether or not it would be used that the approach sidebar, if there's something that it's or something like that.
Yeah, that's fine. And if you need me to send the jury out to have that discussion, I'm happy to do that too. It's not a problem. Okay.
And the same with paragraph 2.
All right, state your same position as the TikTok video of Neek Baby, Neekbaby. Is that correct?
Correct, Your Honor. I informed the defense that we would not be playing the video. I might use a screenshot because of the username, which was part of the investigation as to identifying users on the book. But we would not be playing the video.
Okay, so same ruling as to paragraph number 1. As to paragraph number 3, statements by James Howard. Yes, ma'am.
So Your Honor, provided in discovery are literally hundreds of phone calls of James Howard to a whole bunch of different people. And, but none of the calls appear to have anything to do with Demons. There appears to be a call where he indicates to someone, either he knows Melly, quote unquote, or needs to talk to Melly, quote unquote. But there is nothing that indicates there's any conversation from James Howard to somebody about that would be relevant to the charge of tampering.
State you want to use these statements?
We do plan on using the given, not the irrelevant calls, Your Honor, but in the warrant affidavit, PC affidavit, it does spell out that there are numerous calls between James Howard and one of the defendant's girlfriends, Erin Burnett. There were, I believe, 26 calls made to Courtland Henry, calls to Erin Burnett. There's some calls that discussed ASAP Rocky with Mr. Henry, which is part of the tampering case that we plan on presenting. So there are calls that are specifically laid out within the warrant affidavit and the PC affidavit that state which calls we would likely use.
Okay.
All the other calls are irrelevant.
Okay, so for this one, I'll defer on it. Again, each side can make whatever appropriate objection they need to at the time of trial. Again, I'll repeat, if it's an issue that I need to send the jury out to have a more thorough discussion with the lawyers, I'm happy to do that. If the parties aren't in agreement on some of these, I don't know any other way to do it. I don't know what the evidence, witnesses or testimony are going to be at the trial. I would need to hear what that is to determine if this evidence is admissible, if it's hearsay, if there's a hearsay exception, if it's relevant. So as to paragraph number 3, I'm going to defer. That statements by James Howard. Paragraph number 4 is phone calls between Courtland Henry and Junvia Molina, which is Juneviah Molina, Molina. Yes, ma'am.
I believe the state is in agreement with this.
Yes, sir. And I informed the defense this morning that we don't plan on using those calls unless there's a reason I find a call that explicitly has something that shows the conspiracy is still ongoing. I would let them know ahead of time, but as of right now, no.
Okay, so that one is, again, granted based on that caveat. Number 5, hearsay statements contained in writings and phone calls of Terrence Mathis. Yes, ma'am.
And Your Honor, I put this in a motion when he simply to really alert the court. I think that this is going to be an issue I'm sure you're going to want to defer on with regards to the sufficiency of the evidence of a conspiracy. Mr. Mathis is not testifying as a witness. To the extent to which his statements or writings are admissible, I assume the state would be relying on the conspirator hearsay. And of course, the law is very clear that conspiracy has to be proven prior to the admission of co-conspirator hearsay. So I recognize this is a difficult issue for the court to rule on ahead of time without hearing what evidence may be presented. But I think it's important that it is raised at this point so that we're not jumping into hearsay, having objections in front of the jury, all of that. So I really am wanting to put the court on notice that this is a concern of ours and one which I think the court is going to have to address.
Okay, and you want to use this?
We do, Judge, and I think you will disagree on this, but the state's position is that the writings that we intend to use, the calls that we intend to use, while it is maybe Terrence Mathis' voice on the call, it is actually the defendant's words, they're his letters. We do have jail video we intend to present where he is, and it's all explicitly stated in the warrant affidavit and PC affidavit, where the defendant is holding what appears to be a kite, which is a letter. It passes jail, it goes under his door. Another inmate takes it, passes it through the wall. Another inmate grabs it on the other side of the wall and presents it to Mr. Mathis. He then walks over to the phones and makes a call to Courtland Henry. so that
Okay.
there. I can provide Your Honor with the calls that we have used to make rulings ahead of time, but I do think there are multiple layers to these calls. The first layer, not even being co-conspirator statements, I would say they're not being authentically not assertive, but it's a statement of legal significance, aka an operative fact, and therefore not hearsay. And then the other statements that would not fall under that hearsay, non-hearsay ruling would be the co-conspirator statements. And I do believe there is sufficient evidence, either just spelled out in the affidavit or PC affidavit, to explain that there was a conspiracy going on. Obviously, under evidence standard, we do have obviously the verbal acts that we do not consider hearsay as part of the conspiracy. We have the James Howard calls from Mr. Henry. We have payments made by Mr. Mathis's attorney, George Perez. We have the defendant's phone privileges revoked. We have texts between Mariah Hamilton and Geneva Galena. We have other calls Mr. Mathis made to Portland Henry about Ms. Barnett. We have Ms. Hamilton not showing up for trial or deposition. And we have that jail video. Just to make it.
Yeah, last word on this one. Go ahead.
Thank you. About 80% of what was mentioned appears also to be hearsay. I'm not sure what statements of legal significance mean in terms of this actual hearsay rules or operative facts. But it does seem like it is going to be issues we're going to have to address as we see how the evidence comes in. I would remind the court that the dates alleged are April 10th through July 22nd, 2023. And the state has been very cooperative with providing discovery, so I'm sure we're going to get this information. Videos we have at this point appear to all have occurred after the dates charged in information, but that might just be how they came to us. So we'll have a chance to work that out and see if they're really intended to use. I know from court order that we have to have exhibits.
Well, just so you all see it.
Yes.
You don't have to
yes.
turn them into me.
I know, but that will give us a chance.
Yeah. Okay. All right. So I'm paragraph number 5. Hearsay statements contained in the writings and phone calls of Terrence Mathis. I'll defer on that one, and I'll give you a ruling at whatever time it arises during the trial, based on whatever objection either side thinks they need to make. So,
Judge Lindley, I'm sorry, the majority of paragraph 5 and what we've been arguing about is a lot of the state's case. So we would really need a ruling prior to the jury being sworn, because obviously that would affect whether or not we go forward. So if I may, maybe we can put together some calls for Your Honor to listen to, and we can have another hearing date where it's argued prior to the jury being sworn.
I mean, if you want to turn something over to me and have me review it ahead of time, as long as they have it and they don't object to it, I'm happy to do that. I've never heard any of these calls. I've never seen any of these writings. So this is all in a vacuum to me.
And just so, you know, the argument really is the conspiracy has to be proved, not through the hearsay. So having the phone calls aren't going to necessarily give the court the information needed to determine whether there's independent evidence of the conspiracy so as to allow the phone calls that are hearsay. So I think that almost requires an evidentiary hearing.
The state's arguing that some of these calls, the state calls, are not hearsay.
Yeah, listen, I'm not quite sure how I can do that before the trial, but I mean, I'll try to craft some time for you, and this isn't something you want to do tomorrow.
I'm going to get all the calls together, but I can try.
Okay. Well, as to that one, I'm going to defer on it when we get done with our discussion today. If you want me to schedule something in the future, understanding that I'm sure you all know, I'm starting another capital case on Wednesday, so I might have a limited amount of time, but I'll do the best I can for you. On my case on Wednesday,
I might be able to.
well, I think I'm going to decline that invitation at this point.
No,
but-
it's scheduling purposes. It's not anything with the actual case.
Okay, well, press pause on that. Number 6, the resolution of Cortland Henry's case and the resolution of Terrence Mathis's case. Yes, ma'am. All right.
Holla.
Shout out Mickey. Mickey, you gonna be big. Like,
Yeah,
I'm
Trying to conquer the world, coming from where I come from. Hey, this your girl Mickey Truth, #1 blogger in South Carolina. #1 blogger in South Carolina. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast. Come join the Truth Team on Patreon. All documents that I use for my content is available to the members. So y'all come tap in with the Truth Team on Patreon. What's up, Truth Team? I am here, okay? Back to get a touch of love. Yes, I'm at Touch of Love Massage Shop, okay? Now listen, I've been getting my massages through Touch of Love for years, even before it was a shop to come to. But let me show you around, and then I got to get ready because I'm feeling a little tense. And let me tell you, if you work in like call centers, streamers, YouTubers, sitting at that desk all the time, you definitely need to be tapping in to get your massage. So let's take a tour. So it was located in a nice business building. The suite was set up real comfortably. It was like to the back, and the candles was burning. The aromatherapy was definitely there. Okay, so I had to get undressed, and I'm like, yo, I gotta get all the way undressed. But anyway, like I said, being getting massages, Nakia is awesome at what she does, and let me tell y'all, them hands are blessed, okay? I got the full body massage, including, okay, the hot stones. And when I say that hour went so fast, I even went to sleep. And I always go to sleep during massage for some reason. But yeah, definitely needed that because y'all know I had a night ahead of me, okay?
Hey guys, I'm Nakia. I am the owner operator of Touch of Love Massage Services. I always start with the information of what massage is. So massage is the manipulation of muscles. Exercise is the manipulation of muscles. The only difference is we are manually using our hands to do those activities. So a lot of people look at massage as a luxury when really it's a health necessity. So I'm more on the medical side of things. So if you're experiencing any pain of any sort, muscles is 90% of pain. So I would recommend you to come and get a massage.
How can they follow you?
I do have my business page, Touch of Love Massage Services, on Instagram. I have Touch of Love Massage Services on Facebook. And if you want to set an appointment with me, you can look me up on Setmore. It's an app platform online where you can book appointments.
Hey, there you have it. And y'all, I feel like a new woman, but now it's time to party. So I'll catch y'all in the next one.